Good evening and welcome to Reasonable Robot. I realise for a number of you it's actually not evening, it'll be very early in the morning, notably for you, Ryan. Thank you for joining us. Today we'll be discussing reasonable robots, a discussion between Professor Ryan Abbott and Professor Jeannie Marie Paterson. This webinar is co-hosted by the University of Melbourne Centre for AI and Digital Ethics, CADE, and the Australian Society for Computers and the Law, which I convene. Let's begin by acknowledging the First Nations people of each of the lands on which we meet. Here in Sydney, Australia, I acknowledge the Gadigal people of the Eora Nation and their elders past, present and emerging. If you have a question for our speakers, please use the Q&A function. If it's in chat, we may miss it. And our speakers will answer as many questions as possible in the time available. Let me now introduce Professor Paterson. Jeannie Paterson is a professor of law, an author, a thought leader specialising in consumer protection, consumer credit and contracts, as well as the effect of new technologies in these fields. Jeannie is the co-director of the Centre for AI Digital Ethics at the University of Melbourne, a cross-disciplinary research, teaching and advocacy centre. We are also honoured to have Jeannie on the AUSCL National Advisory Council. Jeannie, now over to you to introduce Professor Abbott. Thank you both for joining us this evening.
Thank you so much, Marina. And I would also like to acknowledge the traditional owners of the land on which I am currently, the Wurundjeri people of the Kulin Nation, and pay my respects to their leaders past, present and emerging. I'm delighted tonight to be here and to be able to speak with Professor Ryan Abbott about his recent book. I'll just tell you a little bit about Ryan. So he has a number of degrees, but he's a professor of law and health sciences at the University of Surrey School of Law, an adjunct assistant professor of medicine at the Geffen School of Medicine at UCLA, and a mediator and an arbitrator with JAMS Incorporated. Now, Ryan is the author of the book we're going to talk about today, The Reasonable Robot, Artificial Intelligence and the Law, published in 2020 by Cambridge University Press. But he's also published widely on a range of topics covering life sciences, intellectual property, in legal, scientific and medical journals and books. And his research is featured prominently in the media. Professor Abbott worked as an expert for a number of organisations, including the UK Parliament, the European Commission and the World Health Organisation, and the World Intellectual Property Organisation. And he also acts as a licensed physician, a patent attorney in the US, and a solicitor advocate in England and Wales, as well as specialising in intellectual property, and indeed is a leader in that field. So we're delighted to have Professor Abbott, Ryan, as we'll call him tonight, here his most recent work. Now, just as a bit of background to the book, in my case, I came across it last year, was recommended by one of my students in a subject I was teaching, which was called Regulating AI, and that student told me that I would like this book. So I bought it, and I certainly do like the book. And so I was delighted when Marina asked me to be involved in this session. Now, the book deals with some of the really big questions about how the law responds to emerging technologies, AI, as it's sometimes called, and also robots in our lives. And it asks that question of whether AI can fit seamlessly into existing law, or whether we need an AI-centric law, a question that I think many legal scholars and practitioners have been pondering about, some with more urgency than others. Now, the book was published in 2020, but I'm expecting that it was a few years making. So Ryan, tell us about the genesis of your book.
Well, thank you first for that overly generous introduction, and it's a real pleasure to be here. Thank you for having me, and thanks to all the people who showed up who are coming from areas of the world more interesting than where I am currently. The book started in around 2013 when I was doing two things. I was teaching patent law, and in particular, the law on inventorship. and I was doing work for a biotechnology company. And if you don't know this about biotechnology companies and drug development, you can outsource just about every aspect of drug discovery to a contract research organization if you're so inclined. And so in my job, I used to get emails all the time from these companies promising to do things for money. One of which was, if we gave them a therapeutic target we wanted a drug for, they would have an AI go through a large antibody library and say, this is the antibody you should be using, and provide a bunch of supportive data. And I thought, well, that's interesting, because when we have a human do that sort of thing, it makes them an inventor. So what happens if an AI does it? I wonder if anyone's ever thought about that. And it turned out people had been thinking about it since the 1960s at least, but kind of on the view that, well, if a machine did do something like this, it wouldn't need a patent. I mean, or no one would need a patent because machines don't care about incentives. And I thought, but that doesn't quite seem right, because the companies that are investing in this need patents. And what should it matter if you have a machine do it or a person do it? And that was kind of my entryway to thinking about machines stepping into the shoes of people, doing human-like things, and finding that two different sets of legal rules applied to behavior depending on the nature of the agent.
And the book has certainly both covered patents, but also gone a fair way further than that in thinking about the relationship between the AI and the law, and indeed how the law should think about this entity as doing things that people do. But let's just do a bit of ground clearing before we go any further. So AI, artificial intelligence, is somewhat of a loaded term, even a controversial term, because there's many views about what it might mean. And as an alternative, we sometimes hear scholars at least speaking about automated decision-making or our processes. I think we shouldn't get lost in definitions, but it's worth just talking about what we mean before we continue. Now, I don't think you're equating AI with human consciousness or self-awareness. So do you want to tell us a little bit what you're talking about when you talk about robots and AI?
Sure. Well, and it's kind of remarkable as we're thinking about regulating new technologies that we don't seem to have a set of definitions we're happy to use, because you really ought to have a definition for things you're legislating around, but I tend to think about artificial intelligence functionally and very broadly as essentially a machine that acts in ways that if a person was behaving, we would, attribute intelligence to. Well, I just used intelligence to define artificial intelligence. Well, machines behaving in ways that would otherwise require human cognition. And I think that works well as a definition, for legal purposes, because I think that the law should be very focused on behaviors and outcomes and rules that generate better social behaviors and outcomes. And so to me, whether something's a robot or a machine or an algorithm or a neural network or an expert system is of secondary, if any, importance. If you have a self-driving Uber that looks like it's going to run you over, you don't really care if it's a robot or a neural network or an expert system. You just don't want to get hit by the car.
I think that's a really important insight, because the individual facing the technology isn't seeing the backward processes, it's seeing the impact of that technology on them. And that is actually the bit the law regulates. So I think that's a really good place for us to work from. Now, and it leads nicely into my next question, which is the central thesis of your book is what you describe as a principle of AI legal neutrality, which asserts that the law should not discriminate between AI in the sense you've described it, doing human actions that require humans or have required humans, should not discriminate between AI and human behaviour. Can you tell us a bit more about this principle? Because I think it's the central thesis.
Sure, and I think it's best seen by thinking of a couple areas in which it applies. So, for example, if Pfizer has a team of human researchers, it says I want a cure for COVID, and they go and invent it. Or if Pfizer works with Microsoft to have an AI that comes up with a cure for COVID, it's not clear to me that there's a reason why we should grant one or the other of those inventions a patent. right? Or if you have Katy Perry or a machine that makes Katy Perry-like songs. But right now, in many jurisdictions, and certainly on the patent side, you could only protect the human-generated invention and not the AI-generated invention. And that seems to have a host of perverse outcomes. Or in the self-driving car context, as we briefly discussed, self-driving, you could use an Uber app to either summon a self-driving Uber or a human-driven Uber. And yet those two different actors have different liability regimes, because when a self-driving car causes an accident, the manufacturer is held to a strict product liability standard, whereas when a human driver causes an accident, it's held to a negligence-based standard. We see some other perverse outcomes from having two actors doing the same sorts of things, but being subject to different liability rules. Or in the tax setting, if my employer, University of Surrey, could get a robot to automate my job, which they will someday, they would save money doing that, even if we were both equally good, because they have to make national insurance contributions for my work and a host of other reasons. But the machine is taxed more favorably. So we have different tax rules applying to human behavior and AI behavior. And again, this results in some perverse outcomes. So having these two different legal systems, I argue, results in negative and socially harmful consequences. And I think the solution is to do less to discriminate between these two different types of behavior.
And just to prod that a little bit further, when you're talking about negative social consequences, I think you're talking about not merely sort of economic consequences, some sort of idea of efficient markets or efficient workplaces, but in terms of innovation that benefits humans, or at least innovation that reduces harm to humans. Would that be fair to say as this outcome that we want to be thinking about when we think about the neutrality of law and the need not to have a perverse incentives provided by the characterization of the subject matter?
I think so. I think in general, a principle of AI legal neutrality helps the law achieve its underlying goals better. And what those goals are really depend on the area of the law. So, in tax and labor policy, some of it is efficiency, right? Some of it is also, distributional systems that promote, fair distribution of resources or promote commerce. In intellectual property, it isn't necessarily efficiency. It might be promoting innovation in the case of patent law, or in copyright law, promoting the generation of creative output. In tort law, it's primarily incentivizing safety. In some sense, that's efficiencies, but I think in a broader sense, it really is helping the law better do what that area of law is intended to do.
That's a great way to put it. Let's dig down a bit now. So quite a couple of chapters of your book deal with that, initial trigger question, which is the discussion of whether AI-generated inventions are eligible for patent protection. Now, recently we've seen sort of discussions about music and art, but as you say, this has other sorts of, consequences in development of pharmaceutical products and the like. Now, the law here varies between nation states, but it would be great if you could tell us a bit about your preferred approach and also about the Artificial Inventor Project.
Sure. Well, to kind of carry on the genesis of the book, I wrote a first article about AI-generated inventions in kind of 2013, 2014, and argued that the way we ought to handle this is that such inventions should be patentable, because even though machines don't care about incentives, the people who are using and making and developing inventive AI do care about patents. And this would help, both generate innovation at the point where someone has an option to use an AI, and help encourage the development of inventive AI. And all of this is going to ultimately result in more innovation, which is really the primary purpose of patent law. That if you don't have a traditional human inventor, that the AI should be named as an inventor if it's functionally invented. And the reason for that would be, one, to inform the public that this is an AI-generated invention, and two, to keep people from taking credit for work they haven't done. So if I could get, a Microsoft AI to invent 10,000 things for me, and I put my name on all of them as an inventor, it would really change what it means to be an inventor, and it would discredit people doing legitimately human-centric creative things. And finally, of course, you couldn't have an AI owning a patent, both because it doesn't have legal personality, but more importantly, it wouldn't be able to exploit it. It wouldn't care about getting a patent. It wouldn't make a sense for a whole lot of reasons. So, the user, the developer of the AI could own a patent, but probably most appropriate is the owner of the AI as being most consistent with both encouraging the development of machines that have value and transferring that ownership through property law, and consistent with doctrines like accession or first possession of items. So I wrote that and went out and started talking about it. And in the course of a few years, people went from, saying it was mildly interesting to businesses coming up and saying, we've got some concerns about this, because even though we don't really just give problems to machines and have machines solve the problems, the teams working on these issues are getting larger. They're getting more interdisciplinary. The machines are doing, the lines are getting a little blurrier. And it's really not clear what a court would do about this. The short-term solution is we could just list a person on an invention. You're not necessarily allowed to do that, but no patent office would question that disclosure unless you got into litigation. And at a certain point, when there was enough interest, I and a group of other patent attorneys thought we should file a legal test case on this. So we worked with Dr. Stephen Thaler, who invented an AI called Dabus, and that's a neural network-based machine. And it generated 2 inventions without a traditional human inventor. We filed these in about a dozen jurisdictions worldwide. The applications were evaluated by the UK and European Patent Office and found to be patentable, minus the inventor issue. And when we corrected inventorship and said the AI was the inventor, these applications got rejected. They've been rejected in the US, the UK, Europe, Germany, and Australia now. And all of those appeals or rejections are under appeal.
Wow.
I was talking for a long time, so I forget if I answered the underlying question.
No, you did answer the question, and I'm wowing because I'm interested to see this play through the court. But I also would comment that that's an interesting perspective on it, because you weren't just talking about innovation, about encouraging innovation, which is generally seen as a good and something we want to do through patent law, but you're also talking about the transparency there and saying it's really important that we're understanding how these inventions came about, which is a perspective I hadn't thought about, but I think a really important one if we're thinking about the humanness of what people do and the differences between us and machines.
Right. Well, and I think different jurisdictions and different legal, I guess I'll say cultures, that's not different legal traditions, place different weights on some of these values and competing goals we have in intellectual property. So, kind of in the US, UK vein, especially patent law is really an economic sort of incentive. We really want to generate innovation, on continental Europe, there's much more of an author's moral rights perspective to, and particularly things like copyright. But, there's no reason why you couldn't have a scheme like this that helps to promote all that. And I think, in particular, companies which own most patents really could care less who's or what's listed as an inventor on something. They just want to get a patent. But, there is a purpose to accurately declaring inventorship, and it does provide particularly moral rights to human inventors who are acknowledged for their hard work. And
now I'm going to pause here to answer, just to direct a question. Carl, you've asked a question. We're going to come precisely to your very question in a minute, so hang on to that one. And I would remind people to put it in the Q&A. But Patrick raises a question: are you implying that the algorithms that make inventions have agency, and questions whether the algorithm has agency? I don't think that's what we're saying when we talk about the difficulties of naming the AI as the inventor or not. Do you have a comment about that agency point, Ryan?
Sure. Well, let me do the narrower IP focus and then kind of the broader point about that. So no, did it subjectively want to invent something? I suppose the answer to that is no, and it's irrelevant. It doesn't really matter that a person told a machine to invent something. in the same way that I tell a research scientist who works for me that I want them to invent something, for patent law, I think the question should be much more who's being told to do what and who's doing what when, not subjectively what is going on in their head or what is going on within an artificial intelligence. Did an entity engage in a process that resulted in inventive output, and can that output be protected? I certainly, and I saw one other question that's exempt, firstly, wouldn't think that the AI should own the patent. As I mentioned, I think it doesn't work legally, but even if you could change the law and you could change the law, it just wouldn't make sense, right? The person who owned the AI would own the patent. But this is why AI legal neutrality doesn't focus on non-discrimination between people and machines, but behavior by people and machines, right? So it doesn't matter if an AI is intentionally doing something in the way we attribute intentionality to a person, right? And principles like culpability or retribution may not be relevant in the case of an AI, but we do very much care about how an AI behaves. And there is a way to construct rules that result in AIs that behave in ways that we prefer socially.
I think that's a lovely point to lead us into your discussion of tort law, because again, that theme of we need to be looking at not the intentionality or the culpability of the AI as an agent, but the effect of its actions on citizens, people around it. So, Ryan, in chapter 3, which is probably my particular interest, but obviously part of a very profound book as a whole, you talk about tort liability and you use as a primary example autonomous vehicles, but although the arguments extend to other types of AI and robots, robot surgeons, recommender tools, and so on. Now, looking at liability for accidents, you're talking about physical accidents, but again, we could talk about economic harms. You advocate, and I am simplifying, that the appropriate standard's not product liability, which is a form of strict liability that focuses on whether there's a defect, but you suggest that the proper tort characterization is one of negligence, because you're concerned that strict liability provides a disincentive to innovation without a consequential gain in safety, which is the sort of well-being protection against harms element. And you suggest that thus it's the act of the AI should be evaluated in comparison, at least currently, to that of the human when we're thinking about the liability of an AI for an accident. Could you talk a little bit more about this reasoning, perhaps continuing with that that automotive vehicle example?
Sure. Well, so when we are probably in a few years now sharing a street with both machines driving cars and people driving cars, those two actors are subject to different liability regimes. If the self-driving car causes an accident, liability is under strict product liability. So this asks, was there a defect with the machine or a problem with advertising with it? And if so, did it cause an accident? And if so, is it liable? And of course, again, just the way an AI wouldn't own a patent, the self-driving car wouldn't itself be liable. It's a commercial product. The manufacturer of the car would be liable, and that's the right framework for it. It's probably the right framework for products generally. It's a higher standard than negligence liability, and we like that because manufacturers should be incentivized to make safe products. They're in the best place to improve product safety. But it doesn't work out that way if you have an alternative that's held to a lower liability standard. So with negligence, we just say, well, would a reasonable human driver have caused an accident? If yes, then you're not liable. And if no, then you are liable. So you could have these two things operating in the same sort of way, but one is held to a higher liability standard. And that isn't good if it's safer than a human driver, because then you're discouraging the use of a safer technology by having a higher liability standard. One of the other problems with it is if that does require looking at a defect in an AI, that's a very resource intensive sort of inquiry, or it can be. And for most auto accidents, it may be cost prohibitive to find there was a defect in an AI. it's much easier to just objectively focus on what did an AI do? Did it run a red light without a good reason, right? If so, and a reasonable person wouldn't have done that, it's liable, not what was going on in an AI that caused it to run a red light. I think, though, what's more interesting here is not what this is going to do on autonomous vehicle adoption, because self-driving cars are just going to keep getting safer. There's a lot of reasons for manufacturers to want to make them to be safer, aside from tort liability, for reputational purposes or to get people to buy more cars. The hardware and the software and the sensors are just going to keep improving. Eventually, self-driving cars are going to be almost completely safe, in which case, the really dangerous actor on the road is human drivers, who cause 94% of accidents through human error and who result in about 1.3 million fatalities a year, or 30,000 in the US. And then the question sort of less, well, what liability standard works for machine drivers, and more what works for human drivers. Elon Musk has said, well, we should just keep human drivers off the road. That's an approach, and maybe the safety benefits are so great we should do that. On the other hand, it does seem to limit some things we care about too, like human freedom and autonomy. And so maybe a better solution is to say, well, if it's practical to automate, the actor's behavior, which sets the standard, should apply to all actors. So if an accident got caused, we'd say, well, would a reasonable self-driving car have caused this accident? And if so, you won't be liable. And if not, then you would be. And as a practical matter, a human driver would almost always be liable, because a self-driving car could stop any accident through superhuman sensors and ultra-fast decision-making. And that's a little unfair potentially to human drivers who are doing their best, but on the other hand, someone is choosing not to automate when they could do so safely and putting third parties at risk. And even for drivers now, for example, who have slow reflexes or severe anxiety, we don't give them a lower standard, even though they're doing their best. We hold everyone to an objective standard of what, a reasonable standard in a field would do. So I think, judging AIs and people when they're doing the same sorts of things interchangeably best promotes the use of the safer standard.
Okay, I like your argument, but as we've talked about, I'm consumer protection lawyer. I really like strict liability as a standard when we're talking about products. So I'm just going to push you a bit further there. I'm hesitant now in the here and now. So not when we have self-driving cars that are highly sophisticated and able to navigate our road systems, but in the here and now, if the standard that we judge AI to is a negligent standard of our person, aren't we aiming too low? I mean, isn't the whole purpose of introducing automated systems to raise the standard? But if we take that strict liability standard, not only are we kind of making it easier for people who are harmed to prove their case, so that could be debatable, but we're trying to lift the standard. We're saying what's reasonable to accept from an automated system.
Well, I think firstly, even if this wasn't really your question, but it occurred to me while you were saying it, even if we set that as the standard today for a self-driving car, and human drivers tended to be better than self-driving cars, that would still work, because then the self-driving car would be liable for accidents it's caused because human drivers shouldn't have caused those same accidents. But once self-driving cars get safer than people, I think you're better off replacing human drivers with self-driving cars than you are getting further incremental gains in the safety of a self-driving car. And I tried to show that through elementary math in the book, and I wouldn't want to butcher it here. But if you have a self-driving car that's, say, 10 times safer than a person, given that almost all accidents are caused by human error, getting one human driver off the road for one of those self-driving cars will prevent a lot more accidents than it would to make the self-driving car 100 times safer than a human driver, because it's already causing a relatively small number of accidents. So at some point, you get more benefit replacing people than you do getting further incremental safety gains. As to when that happens exactly, that may depend a bit on the area you're looking at. But I think in driving, getting people off the road is going to be just about the best thing we can do. And that's just a nudging way of doing it.
Okay, I think that's I'm still interested in the strict liability argument, but I'm happy to move on from that one. I think that there's, this sort of reasoning is interesting to apply in the field of services, for example, financial advice or perhaps other kinds of, advice. And then we're still unpacking just where we set the standard. But certainly, I think this idea that we shouldn't make an assumption that we should be treating the AI differently from the human is an interesting one, and a prompt to us to really think about the types of incentives we're trying to promote through regulatory systems, which is really important here, right? So let's go on a bit with this, with your point about your futuristic point. And you've really started to alert to it because your book is titled The Reasonable Robot. And for those of us who are educated in a common law system, that's got a lot of resonance because, of course, the standard that we've traditionally used to assess tort liability, but also indeed contractual interpretation, is the standard of the reasonable person, man. So tell us a bit more about this flip that you're suggesting to the standard of the reasonable robot. You've sort of led us into it, but let's take that a little bit further.
Sure. Well, essentially, it is the idea that even if an AI couldn't be reasonable in the sense that it isn't going through the same sort of mental processes that we, attribute to people who are reasonable, it can at least behave in a reasonable sort of way. It can behave in a sort of way where we want to hold it against what we currently give human standards of reasonableness. And it can even behave in such a way that we want to hold people to its standard of behavior. And so essentially, yes, in even criminal law sometimes, in contract law, in tort law, in, I think there's some other areas of law. But I mean, in general, there are a number of areas of the law where we have standards based on amorphous beliefs about human behavior and the sorts of behaviors that we want to encourage. And the argument of the book is essentially that as machines step into the shoes of people and do these same sorts of activities, we want them held and setting similar sorts of standards, regardless of how they're programmed and regardless of why machines execute certain programming. Because also behavior is very functional, as opposed to design issues. And really what we want is to have rules that encourage good behaviors, and we will let the designers of AI figure out what design features accomplish those good sorts of behaviors.
And thereby lies the flaw in my argument about strict liability, in fact, because of course the defences to product liability often relate to the state of knowledge at the time, or whether there was whether there really was a design flaw. Where if we look at the effect of the behaviour, we are in fact capturing the interface between humans and machines, which is perhaps what we really are interested in here. Now, we have heaps and heaps of questions, so I think this is a great time to move to some of our questions. And I'm going to start with one that came up, which is relevant to what we've been discussing. Patrick, I'm going to take, is that a Kantian approach, as a comment rather than a question? Though a nice one. Let's start with Paul Nolan's question. Ryan, are you able to see that question, or do you want me to read? I suppose I should read it out. Paul says that he hopes you're well. And he says, how do we go with autonomous vehicles that have some level of human involvement? And I know you do actually discuss this in the book. Is there a sliding continuum between none at all? And can this be accurately assessed so as to portion between product liability, strict liability, and compulsory third-party fault-based insurers?
Well, great questions. I think the short answer is the near future is almost certainly going to involve optimum safety through some combination of human and AI activity, either through an AI not automating, but automating certain tasks or automating under certain circumstances, similarly for the generation of creative and inventive information, output, and that this is something the law should accommodate and encourage. And I think that there are already ways that we do that sort of thing. So, in the intellectual property context, it may be not that a machine has solely invented something by itself, but that it has done something that traditionally qualifies someone to be an inventor, and so has someone else, and they might be joint inventors on it. And that might be important if, say, Pfizer and Microsoft were collaborating. I'm not using those two companies for any particular reason, right? But Microsoft, provided some sort of benefit to which it should be entitled patent protection, and it's through its AI, and so did Pfizer. In the case of the self-driving car, to the extent that you have two actors who are both in some sense responsible for an accident or some part of an accident, we also have rules that kind of divvy up responsibility when people contribute in that way. So you might have joint and several liability for, say, the Uber fatality in Arizona, where the Uber didn't detect a pedestrian crossing the road, but also there was a backup driver who, was watching a TV show on her phone, and a pedestrian who was crossing the street late at night. So there was plenty of fault to go around in something like that. And where you have, I think that answered it. And I see someone was posting about the Uber case right there. And the other part of Paul's question, which seems to have gone out because it's been marked answered.
Oh, that was me. Sorry.
Oh, no, it's okay. It's okay.
You can bring it back up if you click on answered. Is interested in compulsory third-party insurance, which...
Right. Well, I mean, I would say there that, so if you did attribute liability through an actor, say you had both human liability and AI liability, if they were both under a negligence system, right, then you wouldn't have to make a distinction again between product liability and otherwise. The human driver would have their liability, but that would in practice go through their insurance policy, and the AV's manufacturer would have their liability, which might also go through an insurance policy. I
mean, insurance is we generally treat insurances as not the issue here, because if liability is high, insurance premiums go up. If liability is low, insurance premiums go down. So in a sense, it's a barometer for what the core liability is. So I think that's absolutely right.
Yeah, and I mean, the final point, and I agree with that, and the final point I'd make about insurance is, there's a lot of concern over, well, who's going to pay for it when a self-driving car runs someone over? And I think really in all the cases without fatalities where there's been an accident, these cases have paid out very quickly. I think it's going to be a lot easier for people to recover from accidents from self-driving cars because they're commercial products with manufacturers who have deep. You're a lot less likely to get issues with, inadequate compensation than you would with underinsured motorists and hit and run accidents.
And we could say the same about robot surgeons as well, or robot, medical advisors, that these are going to be sitting in quite well-funded regimes. So if we can get the core liability right, the funds should be there. Though from my perspective, the robot surgeon's probably an interesting one too. And I'm throwing this to you as a bit of a wild card because we've been talking about automated vehicles. Because in automated vehicles, the conversation we've had, it's been fairly easy to allocate the fault. You ran a red light, you didn't indicate when you were turning, you changed lanes without looking. The robot surgeon, I think, is in there. You have those problems of sort of complexity and specialisation that have always made it hard for individuals to bring compensation claims in the grounds of product or for products that have harmed them. Do you think that the analogy of the human surgeon works in that context as well? Just to put you on the spot.
I do think it works well. We have, robot surgeons, but they're not really robot surgeons. They're just sort of fancy tools, and they're not really replacing anything that a human being does at this point. But I do suspect this decade will get some of that. Certainly we have AI kind of intruding in the diagnostic fields with pathology and radiology, and a number of AI companies say they have AI that can outperform physicians at narrow tasks. Those Da Vinci robots in 10 years, or certainly in 20 years, are going to be able to remove, a cancerous polyp or, a skin lesion or whatever. They may do it faster than a human doctor. They may do it less invasively than a human doctor. They may do it with objectively better outcomes. And I think you've got a similar situation there to the self-driving car, where you say, well, really, when you can have a robotic surgeon that objectively does a better job of doing it, do you even want the human doctor doing it? I'd say no. And one way to get that, would be to hold them both to the standard of a reasonable machine. At some point, we're probably even more concerned about this, where when the machine does such an obvious doctor, we probably do just want to to even go in there as a human doctor. As to the complexity of these robots screwing up surgery, well, I agree it is probably a little more difficult to prove a surgery gone wrong than a traffic violation gone wrong. But I think it'll probably be easier in both cases when a machine's involved, because machines have so much data associated with what they're doing, right? If you have a bad outcome from a surgery, in some sense, you are relying on the surgeon's test and an expert of your own who's trying to go back in time and imagine what probably happened. With the robotic surgeon, the entire thing will be recorded, and if there is ever a dispute about what happened, I think it's going to be far more objective and transparent about what went wrong than a human surgeon who messes up.
Okay, I think that's a good point. I think that may have answered, and I'm sorry, Jane Price, I think that's answered your question, but if it hasn't, just type in a follow-up for us. And we now also, I think, lead to the question from, there's two kind of related questions. One is from Carl, who I thought we'd answer. I think we've answered, but it's there's a question from Carl and also a question from Jeannie, who are both, I think, still wondering about why it's problematic to hold machines and humans to different standards, but also conversely, whether we're being too forgiving on humans. And I may have summarised your question wrong, Jeannie, but we can start there, and you are welcome to pop out a follow-up.
Why it's problematic we hold them to different standards now, and have we been too forgiving to humans?
So Carl says the actor in the self-driving Uber is different from the actor in the human-driven Uber, so how is it perverse to hold them to different standards? And then Janine says, why is it more acceptable for a human to have an accident than a machine? Is there an unconscious bias? I think Jeanine may be speaking about me, that may have been taking that model, but
no. Well, right. So I think answer two answers question one. Wait, question two answers question one. So yes, there are car, but functionally they're doing exactly the same sort of thing. And what do we want out of a body of law around auto accidents? Well, mainly we want to promote safety and prevent auto accidents. So why would we hold them to different standards if they are essentially interchangeable actors? Now that does require that you have an interchangeable actor and the reasonable ability to automate. If Tesla could make a perfectly safe self-driving car, but it cost $1 million, obviously, then we couldn't implement something this. But when it is practical to automate, putting them both on the same standard drives adoption of whichever actor will be safer, right? And also taking into account there's lots of other things that determine whether or not someone would automate. So this is only one aspect of it, but it is an aspect that would promote, again, kind of the better standard on whatever you're evaluating it for, in this case on tort based on safety. To do otherwise, to say, well, we kind of care about what's happening in the car and what's happening in someone's head is, I think, kind of, violates the reasoning behind why we don't hold people to different standards of drivers. I mean, that's like saying there's a Formula One driver behind a car and me, without my glasses in the other. Clearly the Formula One driver could do a better job of driving a car, but we still have an objective baseline of the sort of conduct we're willing to tolerate out of a driver. And I think that baseline changes in a world where we all have self-driving cars that could do a much better job driving than us. The second point was on, so one Uber killed one person in Arizona, and this had an unlimited amount of media 30 human beings killed other people driving that same day, and there were no reports on those. What makes this different? I think there's a scholar at ASU whose name I'm not remembering at the moment who calls it robophobia. But I think that's essentially, people reacting to bias of an AI should be perfect. And this is something we see in other areas too, like all of the controversy over algorithms used in hiring that display bias. Of course, that's a very serious issue, but also human beings have been displaying bias in hiring decisions as long as we've been taking account of something like that. And if anything, I think we're far likely to get better outcomes from machines because it's easier to detect bias. If you ask a hiring manager, why didn't you hire this person? No one is going to say, well, I didn't like their race or gender, right? Or very few people are going to say that. And if you detect a hiring manager doing that and say, you're not allowed to discriminate on the basis of race and gender, they'll say, yes, of course, but it's very hard to enforce that sort of thing. And AI doing that is far easier to detect. It's far more transparent and explainable about why it's done that or what proxy variables it might be using. And it's easier to correct because you can instruct an AI to follow a rule that it will not violate.
Yeah, I think the bias, I think the bias question, the hard thing is I agree with you that humans carry lots of bias, and we know that if we look at certain professions, including my own, or our own, in fact, sorry. But I'm not so sure about it being easy to self-correct given the sort of layers of indirect, the layers of the bias that comes from indirect associations. I mean, you can say don't discriminate against women, but other groups, but there are other ways that preference in favour of what's gone before can be exhibited.
It could pick other variables to use that would have the same effect as discriminating on the basis of sex. And not necessarily that AI will be less biased. It would require a conscious effort legally from corporate governance and socially to demand less biased AI. The point is that it has at least the potential to be less biased because indeed you can tell if an AI is practically discriminating on the basis of sex, because it is using these other variables, and you can instruct it to stop using those variables. I mean, it is a constant process of good governance around bias, identifying the importance of addressing bias, constantly monitoring for bias in AI, deciding why an AI may be acting a certain way and correcting it. And if one has those governance systems in place, I think you will get far less human bias out of an AI.
It's a nice way to put it, but it also leads us to Sadar's question, and I hope I'm saying your name properly, Sadar. Sadar asks, does this mean you consider how the AI comes to a solution to be less relevant than the outcome on people, and what consequences does this have for regulation of AI, including, I think, the process through which the decisions are arrived at, which is something that's important in administrative law. And equally, Atif asks a similar question without wanting to take the sophistication and nuance out of your questions, which are very good questions. Atif asks about the role of transparency in debates about regulation.
I think the answer is sometimes, certainly in the context of things like tort and intellectual property, I think it's much more important. Did the AI generate some patentable output? Did the AI avoid an accident? And we should care very little or none why it did that. Sometimes outcomes and transparency are at odds. So for example, if I have an AI that is completely accurate at detecting skin cancer, I don't think I really care why it detects it, except, out of interest to human doctors and so forth. But that is something that has an objective outcome that is measurable and, not in question. There is skin cancer or there isn't. If you look at an AI that's doing something like making sentencing recommendations for whether or not someone should get bail or not, well, that's not sentencing, but making sentencing recommendations in a criminal context, That situation's different because there isn't such an objectively right answer to the question, how long should someone go to prison? You know, that is, and for that reason, I think we care a lot more about why someone is coming to a decision than necessarily even what the decision is. You know, what factors are you taking into account in doing this? So I think it really depends on the context and how objective the outcome is, whether we should care about process some or not at all.
Thank you. I think that's a really nice way of thinking about that issue, of framing the considerations for when explainability is the important question, or explanation, and when we really should be looking at the impact on individuals. Something that's very important, I think. Now, Helen has a kind of related question, Helen Stamp. She says, any thoughts on algorithmic accountability auditing, which is looking into the in the decisions rationale made by the person responsible for the commissioning development? And I would add governance, to pick up your point, of the AI and how this impacts on liability.
Yeah, so I think that if I'm understanding the question correctly, you know, from a regulatory perspective, I don't think it should matter. We should be asking, you know, how the AI is behaving. But from a, you know, corporate governance or internal risk management perspective, of course, if you're building a system, you know, what the AI does is a feature of how it is designed, right? And that goes into how you are auditing it and making sure it works. So, you know, Tesla can't just say, well, do our cars run people over? They need to understand, you know, how the system works and to be auditing it regularly and to have appropriate governance frameworks. You know, that translates down the chain to the third party who was injured with a simple question: did the AI do something reasonable or not? But, you know, for manufacturers and companies, the way they can impact that is through auditing and governance systems.
Yep, I think that's even if we're looking at conduct, we don't give up on governance. Now we've got so many questions. I'm going to go to Seb's question because I think this comes to the heart of the matter about what you're saying. So Seb says, going back to our doctor's example, is a machine, or better said, a program performs the surgery wrongly, will the liability go to the programmer? And then says, if the AI has not reached singularity, but it's been the process of a cumulative decision, a set of cumulative decision-making process on its from its coding onward, what does that mean for your argument? I think that's actually an important question, Ryan, because I think what you're talking about here is the standard by which you assess liability, not the idea that the AI itself will be liable. Do you want to speak a little bit about that for us?
Right, no, that's exactly right. So who would be liable if a robotic surgeon messed up? A robotic surgeon is and will be a commercial product, and under standard principles of product liability, the manufacturer or supply chain parties would be liable for harms caused by the robotic surgeon. My suggestion is, though, instead of asking whether the robotic surgeon screwed up in a product liability framework, we asked whether it screwed up by comparison to the behavior of a reasonable human doctor, right? In context where they are exchangeably, engaging in the same sort of behavior. Would it ever make sense to hold an AI directly liable, or for that sense, give an AI legal personality or any kind of legal right? I think one has to distinguish between moral and legal rights in that distinction, and I think corporations do a really good job of illustrating that. So companies don't morally deserve rights. They get some legal rights because these have good social benefits. So a company that can own assets and enter into contracts promotes entrepreneurship and, generation of wealth and so forth. But companies aren't like people. An AI could get some kind of legal right, and I'm potentially open-minded to the idea that in some context it might make sense. So you could have a self-driving car that has the legal right to own an insurance policy. So if it goes out and causes a harm, it could pay for it. On the other hand, I still can't think of any setting in which a system like that would be helpful or really make much sense, because why make an AI liable when the AI's manufacturers could be liable? And it is the AI's manufacturers you're trying to impact with these regulations. By having the AI's liability go to them, it encourages them to make, use, and develop safer artificial intelligence. The incentives do not directly impact the AI, but the people making and using it.
Thanks. Now, unfortunately, we're running out of time with these fantastic questions, but I just want to go back now to where we started, which is patents. So we've got a great question from Rob Chalmers, who's been waiting patiently, and Marina will just answer this one and come back to you. But Rob says, if we accept this type of approach for recognition and ownership of AI-generated patents, so jumping back to that conversation, might there be systematic problems arising from the scale and speed of automated invention, especially when coupled to the patent troll business model? Ryan, I know that's a complex question, but do you have a short answer for that one?
Well, it depends what you think of as a problem. If you mean, are we going to have machines that can outdo people, and the cost of copying these machines will be almost negligent, and the cost of having them generate output will be almost negligent, the benefit of that would be a overwhelming wave of innovation. The downside of that would likely be industry consolidation and pushing out human inventors. I tend to think, though, that that's a good sort of outcome, in that it generates what the patent system is mainly designed to do, innovation, and we get all sorts of new inventions for problems we didn't even know we had. Human researchers for the foreseeable future will find other areas to work in they're better suited for. And if we ever get to the point where it completely automates invention and we really have no more jobs to do, well, then machines have really solved all the problems we have, and we can all get to know each other a bit better, or maybe just spend time in virtual reality.
Wow. Well, I'm looking forward to that moment, though I think I'd be spending my time on a beach, to be honest, looking at your backdrop. I'm really sorry that we have to stop. And I'm going to say, for all the people out there that have these wonderful insights and questions, send your suggestions to future talks to Marina, because it sounds like there's a lot we could do here. And hopefully we'll be able to have Ryan back in a little while to tell us how his projects are in fact going. But at this point, I do need to hand over to Marina to wrap up and tell us about another fantastically speculative new endeavour that she's involved in.
Oh, fantastic. Thank you, Jeannie, and thank you, Ryan. I think I'll be joining you on that beach as well. Ryan, hopefully it's an Australian beach and you can come and visit us. Also, our guests from over in Germany and France, of course, you're all very welcome. We pride ourselves in having a very open and welcoming society at the Australian Society for Computers and the Law. On behalf of all of our members and Cade and everyone attending here and those who will be listening in on demand, we thank you both very much for your time. Very generous with your time and your insight. Grateful on all accounts. We have a few other events that we'd like to mention here. Thank you very much, Gabby, in the background for sharing the screen. Very quickly, Future Histories is coming up in May. Two barristers sharing thoughts on two Australian barristers on the issue of human rights and what can the past tell us about future protest and other aspects. Rules as Code, we have a series of Rules as Code events. This is our Masterclass 3. They are without charge. It's intended to help promote the movement of coding, future law and policy. So if you are able to attend, please do so. We also record those sessions and they're available via our YouTube channel. Gabby, may I have the next slide, please? I'm trying to keep to time, that's why I'm talking quickly. We also support other societies. So the Australian Computer Society, they have a 10-part series on smart places. If you're interested in joining that discussion, please subscribe to us and we'll be very happy to pass the invitation to you. Also, if you're a female legalpreneur, you may be interested in joining that special interest group launch there on the right-hand side of the screen. And I think we have one more slide left. that's it. So some contact details for our wonderful presenters today. Please do follow them and encourage the wonderful work that both Jeannie and Ryan do. And of course, the Centre for Artificial Intelligence and in Digital Ethics. Thank you everyone for joining us, and enjoy your evening, your morning. And if you are fortunate to be next to a beach, please enjoy the beach as well. All the best, and hope to see you at a future event. Bye for now.
Thank you.